Hi, my name's Adam, and I'm here with my very dear friend Bill. And we're making this video to share about a case that we just submitted to the US Supreme Court. Actually, it was in about mid-September, and to give you all an update about it. So if you want to read the suit, it's against 16 state and federal judges. You can find it at www.thespiritoflaw.com. And you can check out all of the supporting exhibits and the procedural history. They're all there that you can either download, print it, or view it online. So at this stage of the game, I'll share more about it in a little bit. But the court has rejected the filing of it based upon procedural rules. So with that, I'll hand it over to Bill, and he can talk a little bit about the court's history of doing that and the treason that's involved in it.
Well, they have quite a history in that area, especially the last 160 years for not doing their job to say what the law is, Marbury versus Madison, for those of you that don't know. And in this case, Adam done the best pleading I have seen, and I've seen some good ones, but this, and he does it, he's much nicer than I am. He uses their forms and tries to get it done in ways they'll recognize it. I go in there a lot more with attitude and authority and say, this is the way it is because we created this whole thing. We own it. This is principal and agent. And yet what's happened to him, I still shaking my head. The justices haven't even seen the petition. And this is where you get, and by the way, if you get on my website, uwinthecourt@gmail.com, I'll send you information. One of the things you get are quotes from a case called Cohen's v. Virginia, 6-264, 1818. Oh, that's old law. They don't use that anymore. Well, the Supreme Court used it twice in the last term in cases involving the state of Texas where they refused to file documents. We're not going to get into that. But what's relevant here with Adams' case is, let me give you a virtually verbatim quote from Cohen's. And this is Chief Justice John Marshall saying it. Their ultimate icon was never wrong, right? At Cohen's, the Constitution gave to every person a right to present his case to the court of the nation, no matter how small the claim, nor how little interest the community and its outcome. The framers of our Constitution thought it necessary for the purposes of justice to create a tribunal as superior to influence as possible, in which that claim might be decided, unquote. And we can't even get documents filed in trial courts now, and Adams' petition doesn't go to the justices of the U.S. Supreme Court. You figure it out. Take it from there for a bit, Adam. Go ahead.
Okay, yeah. So I did send it to the Supreme Court, and I sent 10 copies as was required by their rules. And a majority of the petition is in the format of their rules. But if you go to thespiritoflaw.com and you scroll down on the homepage, there's an update from September 28th, 21. And you can download the clerk rejected filing it because it wasn't in the form of the procedural rules that they said that the Supreme Court's rules, in other words. So what they've done now is they've used procedural rules that they created to deny rights secured by the Constitution. So let me give you just a little bit more context about how that's working. So there's the federal rules of civil procedure are what supposed lower inferior courts of the United States use as their procedural rules. And Rule 5 says, the clerk must not refuse to file a paper solely because it is not in the form prescribed by these rules or by a local rule or practice. Now, comparing that to the Supreme Court's rules, the very first rule, it says the clerk receives documents for filing with the court and has authority to reject any submitted filing that does not comply with these rules. Now, let me give you some more context with that. This is from a case of Miranda v. Arizona. It says, where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. In other words, they can't make procedural rules saying that you didn't put it on the right size paper or you didn't use the right size font and then deny all of your constitutional rights, because that would in effect be overruling or superseding the Constitution. And so there's other cases. One's Nashville v. Wallace, and that says the Constitution does not require that the case or controversy should be presented by traditional forms of procedure, invoking only traditional remedies. The Judiciary Clause of the Constitution defined and limited judicial power, not the particular method by which that power might be invoked. So to kind of summarize all of this is that there seems to be rules for the lower federal courts, but not the Supreme Court. And the Supreme Court can make rules that can overrule or supersede your rights to the Constitution. And these rules haven't ever been to my knowledge, they've never been submitted to Congress. They've never been submitted to the president, or even the public was not even allowed to comment on them. So, as Bill had mentioned one time, the Supreme Court's not a legislative tribunal. So, anyways, that's where we're at. Oh, there's one other thing. I did send a letter to Justice Clarence Thomas, and you can also find that on the homepage of the Spirit of Law website. And I believe it's as of, let me just see, that was sent on September 29th. So we're going on 2 weeks now, this Friday, I believe it will be. So with that, I also want to welcome my other dear friend, Georgette, who is here to be in support.
Welcome.
Hi, Bill. Nice to see you too.
Nice to see you too.
Have you guys met yet?
Not formally, no, but we talked on the phone rather a bit with you. So yeah, we have. So you're a couple of kooks there, Georgette. Look out, we're real troublemakers.
There's nothing I love more.
She's going through her own legal stuff. We can talk about in a little bit. But Georgette, did you have anything? I know you kind of jumped in right while I was, kind of giving a little bit of a background, but what's going on. And is there anything that you'd like to share from your perspective?
I don't think so. Not at this point. But I'll let you know as we go along. Okay. And okay. I may have to leave. How long do you expect we'll be on here?
20 minutes, 30 minutes, maybe.
No, never mind. I'll be here.
Okay.
Okay.
So Bill, your turn, if you will.
Okay, well, some other issues come into play here, and what Adam put in can and should have been construed as a non-statutory federal writ of habeas corpus pursuant to Article 1, Section 9, Clause 2 of the Constitution, which can only be suspended during declared cases of rebellion or invasion, not COVID pandemic. And in effect, these rules, if applied here, would allow the clerk of court to effectively do that. And again, Collins v. Virginia, the court has said in there once again that to refuse to take jurisdiction when you have it or to exercise it when you don't, the one or the other is treason to the Constitution. That's exactly what apparently is happening here. And like Adam, I sent a cover letter to Justice Alito. These are the two that wrote the dissenting opinion, quote unquote, in the case of Texas v. California, and cited Collins, and they did it in an earlier Texas case. And you can't cite that case unless you know what it means. Most of its dicta is not relevant to the decision. It was quite a case in its day. But you have to understand, listeners out there, we have better standing than the states we created. It's a principal and agent relationship. And if they're saying on the one hand that Texas can't file there, and that's the only jurisdiction they have, Article 3, Section 2, in all cases, ALL, in which the state shall be a party, the Supreme Court has original jurisdiction. The mainstream media caught on to this, but they either missed it or were misled, I don't know which, by 5 words. Cases in which a state, and the central issue that I have of all the unopposed issues I advocate, there are no states, and that affects a lot of what Adam's doing in his case too, because if we don't have any states and no judicial courts, whatever laws they use, in his case it was Business and Professions Code, null and void, nunc pro tunc ab initio as a bill of attainder, Article 1, Section 9 or 10, as the case may be. And wouldn't you know what I said about the court not having done its job, the last time they seriously ruled on this issue Cummings v. Missouri in 1867. That's not coincidental. We start making issues like this and get away from this civil rights crap, all of us are going to do a whole lot better and quicker. And I think the court, if I'm reading the tea leaves right, and I've been doing that for 5 decades, this term may actually be seriously considering it, because what I just said with Alito and Thomas, I think they were joined by the 3 Trump appointees, at least, who were told for the moment, for whatever reason, to stand down. Right issue, wrong time. We'll see with them back in session. Are they going to understand some of the points I just had and what Adam put in his material too? If that happens, we are in for a lot of good times here, notwithstanding whether Biden attempts to pack the court, quote unquote. Especially interesting if he tries to do it as commander in chief, which really tells you, and that's why I think the court has their backs up, because if he can do that, he's saying to the Supreme Court, not only you're not a judicial court, there are no judicial courts. That's the only one created by the Constitution. And they're saying, without overtly saying it, that the Constitution has been suspended. And I don't think that's happened. So that said, let me get back to Adam for some more commentary.
Well, that was one thing that I wanted to explore with you both, was the fact that because they refused to file my petition and exercise jurisdiction where the Constitution gives it, where are we at right now? I mean, is that not a tacit admission that there is no Constitution and we don't have a right to a judicial determination of our rights there? I mean, it is, but at what point, do I say, well, they're not going to hear us? I mean, I have a couple of options, meaning I could put it on their forms, so to speak, or not their forms, but format it in the way that they want it to be, which would actually, I think, based upon what I filed, be 2 or 3 different separate filings. First, because they said, if it's the non-statutory writ of habeas corpus, it has to conform to that filing, and you cannot combine that with any other filings. Well, mine was essentially combined with a writ of error. And then they said to that there is no writ of error recognized by the rules. So where that went, I have no idea, because it's a court of law, and the writ of error comes up under the court of law, of common law. And then the other one is essentially a suit against all of the 16 state and federal judges. So getting back to my options essentially are, if Thomas doesn't respond and say that we can file the case, well, then either I go to that route or I stop moving forward in that court and file bankruptcy, unless there's some other option that comes to mind, or, I don't know. Do either of you have any other ideas? Or?
Well, I would say that there's usually more than 2 options. And even if we don't see them right now, again, this is intuitive. I don't get that you either have to file bankruptcy or file several different, what do you call it, petitions or suits.
Right.
That there's something in between there that just hasn't been seen yet. I'm not sure what it is.
Me neither. And yeah, there's definitely options in that regard. Those are 2 of them. Another one is to let the house here, it's my mom's house, go into foreclosure and see what happens in that process. Mm-hmm. But all of these, well, the latter 2 seem to all be a result of the court not being willing to accept the filing, which is so, I mean, as we've been talking, if you strictly construe the Constitution, well, not even strictly construe it, it's just what it says. When they have authority to do something and they have a duty to do it and they don't do it, that's treason. So they're not doing it. And, as far as the letter that Bill and I wrote to Thomas and Alito, what do they have to do but write back and say, file the case as it is and be done with it? I mean, it's not like they have to review it to see if it's worthy of their time and effort. Although maybe they would do that. I don't know. But
I
you
was
know, we're,
I was listening to someone, I don't remember who it was, and they were having a similar problem in having the clerk of court file their papers. And they put the clerk of court on notice saying they were going to sue the clerk of court if the clerk didn't file those papers, and the clerk did after that.
well, that brings up another piece of this, is that after the Supreme Court clerk refused to file my papers that I submitted, I went to the district court in California, the federal district court, and I sued the clerk of the United States Supreme Court in that court for refusing to file the documents and exercising the judicial power of the United States, which he has no authority to do, to deny my petition or my filings, whatever you want to call them. And within a few hours of filing suit, I got an email from the judge who it was assigned to, and he essentially threw it out as frivolous.
Oh, I remember now. Yeah.
Yeah. He said, you know, I don't have this court doesn't have any power to tell the Supreme Court what to do. And I promptly wrote back an amended complaint to him and said, au contraire, it is your duty, if rights are being violated by the Constitution, it doesn't matter who, whether by the Supreme Court or anyone else, you have a duty to protect those rights. And he basically said, bye-bye.
Is there any other way you could sue the clerk of court?
Well, I suppose I could bring another suit in the district court for the District of Columbia, but I'm not sure how that would go, given the fact that the district court here already ruled on that issue, even though it was the wrong venue. I don't know, Bill, what do you think about any of that, or do you have any thoughts?
Well, yeah, there's a lot that goes in, Adam. I was thinking as you're talking, and the DC is attractive. I'm still researching that. I will get back to you. But as you know, I've recently come into, and with your help, by the way, the California District Court, which is there pursuant to the original Constitution of 1849, which the Secretary of State says here, pursuant to your request for documents, there's no record of it having been repealed. Contemporaneously recognized as a constitutional common law court, it would also then have concurrent federal jurisdiction of an Article 3 circuit court. And we don't have any state bar member attorneys that are qualified to be judges in that court. That's our court. They can't even come in there unless we let them. And they can't compel us into their jurisdiction either, which in effect the framers of the Constitution identified for what it was: jurisdiction foreign to our Constitution and unacknowledged by our laws, admiralty and maritime. And just to note here, as Adam knows, I never got my document filed either, but when I was alone in that South Carolina jail cell 5 years ago, I did up an 18-page hand-printed writ of habeas corpus. And you can see I'm sitting here talking to you today because they got that, and I'm sure they got a call in Columbia, get him the hell out of there, because we can't answer these issues, any more than what they may think now, although that's a big change we may see, and it may come in Adam's case. Because 5 years ago, it was clear that I made good points. I had 40 case citations in there, no errors. And here I am sitting here, and they wanted to go after me because I was challenging the South Carolina bar in that case. And they wanted to put me away as long as they could. And here I am. They didn't come close. If I had a video of the first meeting I had after being dragged across the country 2 months, shut them up in 30 seconds flat. That's what you learn to do when you study like I have, and what I can teach you to learn how to do. And you go in there, and I'm the one there manacled hand and foot in a red jail suit. They're the ones in trouble with the law, and everybody knew it. That's power, people. That's what the framers put in our hands. That's what we want to get back, whatever it takes to do it. By the way, another case of this type, not nearly as good as mine, Clarence Earl Gideon v. Louis L. Wainwright, 372 U.S. 335. And Gideon was forced, because he wasn't given anything to write on when he was in that Florida jail, to write it on toilet paper. The Supreme Court took the case, heard the case, decided it, and set him free. It's not my favorite decisions for reasons we won't discuss now, but on toilet paper. And Adam's case can't get seen by the justices, let alone heard and decided? What the hell are we doing these days? And this is apparently the only court, unless behind the scenes they know exactly what I do about the California District Court. If that's our constitutional common law court, that's the jurisdiction and venue. All we need to do, and by the way, the county clerk is identified as the ex officio clerk of that court, Article 6, Section 10 of the Constitution, 1849. And like Adam correctly and brilliantly points out, the Constitution of 1879, as amended, doesn't vest the judicial power of California anywhere. And it doesn't need to, because the body politic that represents isn't the body politic of the Constitution of 1849. Completely different. They all owe their citizenship, such as it is, to Article 1 of the non-existent 14th War Amendment. And you'll learn, send me an email, uwinnincourt@gmail.com. You're going to learn that amendment doesn't exist, and it never has existed, and that's all they have. That's how we're going to beat them one way or the other and put them out of commission. It's simply not there. It never has been. But they didn't tell me, and like you, I didn't learn a damn thing in school 50 years ago, and I wish I would have, right outside of Washington, D.C., when, life would have been different. But better late than never. But they don't teach you, so you don't have any way to know. Attorneys are not going to help you. The only one I've seen was from Minnesota. I'll think of his name here in a minute. That would have even thought to have done that. Nowadays, they're all in the game. They're unregistered foreign agents, maybe agents of the City of London, with the sworn oath to that organization that supersedes the one they take to our Constitution. So these are the things that have to change. Once we understand the perspective and the situation we're in as principals and agents, it gets a whole lot clearer in a hurry. And by the way, I was at the head of the list of being ignorant, to the point when I was 19 years old. What did I do? I volunteered into the Marine Corps at the height of the Tet Offensive. How stupid is that? Knowing what I know now, thank God for my dear beloved mom, who put a curse on the Marine Corps and said they're not going to get them. And sure enough, I get over to Fort Holabird, and the sergeant looks up to me and said, "If you lose your glasses, how will you know who to shoot?" At the time, I didn't know the right answer, which in my view would have been fine. Give me an M16, point me back to Washington, D.C., 1600 Pennsylvania Avenue. I'll take care of the problem. But the Vietnam War, which wasn't a war, it was a UN peacekeeping effort, and we don't belong to the UN. Story for another day. Just like the Korean War, which is still in existence, by the way, and so is Vietnam. All we have there is a ceasefire in Panmunjom in 1953. These still exist, and as Adam knows, in my view and in our view, the war between the states still exists. There's no evidence of a treaty between the Confederate States of America and the United States government. So the behind the scenes, especially the New York banksters, think this still exists. And that state of war with the Libra Code and all that is what they're using to try to get around us. And what just happened to Adam, I think, is a direct result of the Libra Code of 1862. That's what we have to stop, get around and say, not so fast here. We have rights, and it. What's the problem? You have a sworn oath to be bound by this Constitution and the laws enacted in pursuance thereof. What's hard about that? Anybody out there can answer that question? I'd love to hear it. Back to you, Adam.
Well, I am constantly bamboozled by what is happening here, because I really don't know. It's fascinating that when anybody comes from a place of integrity and submits documents to be heard by the agency that is vested with authority under the Constitution to do something, to hear the case and make a determination, and they refuse to do it. Well, that's interesting. What do you do? I haven't shared so far about my case, and I'll do it very quickly. Basically, I was fined about $850,000 for allegedly not having a construction license here in California. The statute is Business and Professions Code 7031B. Now, what I discovered about it is that this is a purely penal statute, and they're supposed to notify you that you have the right to counsel, and the prosecution is supposed to be done by in the name of the people of the state of California and by the district attorney. But none of that happened. This was all done in the civil context. And the private parties that sued me had no authority to do so. And the court therefore had no personal or subject matter jurisdiction to make any judgment whatsoever, because there was no subject matter jurisdiction vested in the court. In other words, the court had no authority to do anything that it did. It had a ministerial duty to dismiss the case right then and there, because there was no power vested in it to conduct a criminal proceeding in a civil trial, or for, more accurately, for private parties to criminally prosecute other private people. So that's what happened to me. And then I went to an appeal and made a lot of the arguments that you'll find in the petition that's on the website. And the court said, we find no merit to any of your contentions. So I went to the California Supreme Court. They refused to hear my case. I filed a petition for writ of certiorari with the US Supreme Court. And like, I don't know how many thousands of other cases they threw out at the swipe of a pen, they didn't want to hear it. So then I filed a lawsuit in the United States District Court here in the Central District of California. That's a, quote, federal court. And that court said that the federal government, sitting as the district court, does not have authority to vacate a state court's, well, they didn't say they didn't have authority to vacate the state void judgment. They basically said that the judgment that was against me in the state court was valid, and that because it was valid, they didn't have any power to overturn it. Well, that's a lie, because the judgment's void because the court had no authority to do what it did. And so they had a duty under the Constitution to vacate the void judgment, and they refused to. So after that, I filed an appeal. And right when I did that, the district court told the Ninth Circuit Court of Appeals that my appeal was frivolous. And then the Ninth Circuit Court of Appeals said my appeal was frivolous, and it got thrown out. So there is essentially no court in the state of California or the United States that I have access to and am aware of, other than the US Supreme Court, that has jurisdiction to hear this case and actually vacate the void judgment against me. So that's why, one of the reasons why I'm in the Supreme Court, is there is no other court. And this judgment is now $800 and almost $50,000, where it will attach to any real property that I ever own. And it's also resulted in the permanent and indefinite suspension of my ability to ever act as a contractor in the state of California. And that was all done without any hearing whatsoever. So that's what the premise of the case is. Either of you want to share anything?
Oh my goodness! Number one, for openness, $850,000, right? "Quote unquote," undefined dollars, paper money, which is beyond the subject matter jurisdiction of any state court. Article 1, Section 10: no state shall make anything but gold and silver coin a tender in payment of debt. We don't know what it is. And if defined at all, people, you're going to love this. And you get onto my website, youwinnincourt@gmail.com. We explain this. This beats them. Because the dollar, if defined at all, and this is the Supreme Court saying it, not me, is by the president, apparently acting as commander-in-chief of the armed forces. And what does that tell you? And why do you see the yellow fringe around the flag every time you walk in there? It's a martial law military court, which they can't do. And that goes back to a really big case called Ex parte Milligan, 4 Wall 2, 1866. That's one you run a lot about to get a hold of my materials. They simply can't do any of this. And yet here they are, primarily for the reason that very few people, know enough like Adam and I do to even ask questions like this. The Supreme Court has to love this. And then you get into what they call their Ashwander rules for status and standing, which was on page 1 of the first law course I took in 1983. By the way, never been through law school, and never been brainwashed by one either. But these rules, what do they say in there? The court will not rule upon the constitutionality of a law in the advance of the necessity of answering it. And they know damn well that no member of the Supreme Court bar in his right mind is going to bring an issue like that. They also know that 99.9% of us who don't know aren't going to have a clue either. And I think that's what lets the bastards go to sleep at night soundly, knowing that they've done their job, but it's not their problem that the American people don't know. It sure as hell is from where I sit. I mean, you just simply can't get around it like that. So we have that. And then, by the way, speaking of the California Supreme Court these days, and good old Tawny Cantil Sequoia, I have from there and multiple times, but the one I sent in, 2013, I believe, I did a non-statutory federal writ of habeas corpus that gets summarily denied. One paragraph that the questions you raise are beyond the jurisdiction of California courts as they appear to present federal issues. They don't have federal question jurisdiction? Whoa, and I'm sitting there in that jail cell 5 years ago in South Carolina. News came on and we had the situation arose in North Carolina where an attorney was making a serious argument, albeit not in court at the time, that a transgender entity, your guess is as good as mine, had a right, to invoke federal jurisdiction because taking a crap in a government-funded bathroom affects interstate commerce. And the California Supreme Court is saying we don't have federal jurisdiction? If you know what you're reading, they're right. They don't have de jure federal jurisdiction. De facto under the non-existent 14th War Amendment is a matter of a whole different sort. They have that all over the place. They don't have this, and that's what they need. And what it means is that they're not a state admitted into this union, Article 4, Section 3. And not only that, now, Tawny and the justices didn't have the courage to do this on the record, which if they had, they'd be out there in San Quentin, hopefully in close proximity to cell 2455 for treason. This was done by a deputy clerk of court. Have you ever heard of the doctrine of separation of powers here? And I've got no less than 12 different ones, not quite as dramatic as this, but the same thing. Summarily denied, just like what's happened to Adam, with no reason, no nothing, no opposition. And I'm going to ask all the official actors out there, if that's the case and we're wrong and we don't know why, how can we make a knowing, voluntary, and intelligent use of our right to vote on quote unquote election day? It's not possible. But conveniently, as you'll learn from my website, there are no elections. And there can't be because if we're in federal insular territorial possessions, Congress is without power to provide for elections. I mean, for president, for officers. You ever heard of the Electoral College? Voting members of the House and U.S. senators, which is still an appointed position, notwithstanding the 17th Amendment, which was not ratified. They're not there. There's nobody in either house of Congress that has any standing to be there, let alone have a quorum to do business. These are the kind of issues we raise and start to get around these bastards, and it's going to work in Adam's case too, because the same thing is true in California. Oh, a quickie there, by the way. I know I'm running on a bit here, but think about this. Article 1, Section 2, U.S. Constitution, maximum relations between inhabitants and members of Congress, 30,000 to 1 in the House of Representatives. We have over 40 odd million people here in California, and we have 80 members in the California Assembly. Do the math, 500,000 to 1. Where is the Republican form of government guaranteed to the states by Article 4, Section 4? Another real beauty of an issue. And like many of the issues, Adam knows this too, the Supreme Court has rarely ruled on this. They hadn't ruled on it since 1842, Luther v. Borden, and they called it a political question at the time, and it might have been, but not the way we're going to be raising it. It's life or death here, literally, of the Constitution and of our lives and our posterity's lives. That's how serious this is getting. So yeah, this is the kind of issues that we want to raise, get before the court, better yet, get before a common law jury, which has the power to rule on the facts and the law. There's that pesky U.S. Supreme Court again, Brailsford v. Georgia, 2 Dallas 402. You had a right to that since the Magna Carta in 1215, Article 24, 34, and 42. And yet you don't see it anywhere. And oh, by the way, just a closing note here, we also have that right under Article 2 of the Northwest Ordinance of 1787, which guarantees it to inhabitants of territories. And yet it's nowhere present in what purports to be the state of California. I'd love to get Tony to answer that question and see where the hell we're going to be going from there. But I went on a bit. Let me get back to Adam.
Georgette, you have some notes there?
Something you just said, Bill, about getting before a common law court. And the question just arose in me, is there a way you can get before a common law court, Adam, with some segment of what you're doing, or the whole thing, or how does one get before a common law court?
Well, this is something that Bill brought up earlier, but in the way of the district courts of California. So every state in the union, with the exception of Louisiana, was admitted under the common law. And so how it used to be that a constitution would vest the judicial power of a state or the United States in a judicial constitutional court would be, they would say in the Constitution, this court has jurisdiction in all cases at law, and oftentimes that was accompanied with at equity or inequity. And what you find now is that if you go to the California Constitution of 1879, there is no court that's vested with common law general jurisdiction. It just says the court has jurisdiction in all other causes. Well, what in the hell does that mean? There is nothing in the Constitution, history, and laws of California or the United States that talks anything about all other causes. What the whole point of having a court at law or a court of equity or admiralty is because there's very specific modes of proceeding and forms that these courts proceed under, and there's very specific types of relief that they can grant. So, like, to bring it back to my case, if you were to apply the common law to the Business and Professions Code that my case revolves around, first off, the Business and Professions Code wasn't even recognized at common law, so it's out already. Second, if they're going to say that the Business and Professions Code is the common law of California, well, it's not, because the common law is the laws of England that came over here that were adopted in California. And the common law recognizes inalienable rights. That's what each of the constitutions was created under, was the common law. And the Business and Professions Code, obviously, if they're saying you have no right to your time and labor in construction whatsoever, obviously you don't have any right to anything. It's a privilege that they're granting you, commensurate with whether you pay a fee or not. So that's one aspect of it. Here's another one: is the fact that having a license creates a hypothetical injury, that you've injured somebody because you don't have their permission to have a license. Well, under the common law, you have to have an actual injury, and there has to be a nexus to that injury that they present evidence of. So you can't just make up something like, wearing pink on Fridays, it results in $1 million fine, because it's just purely hypothetical. It's not based upon anything, and there's nothing to tie it to the fact that an actual injury has occurred. Yeah. So, So
are you saying that there aren't any common law courts, and so therefore, it's not a possibility to actually?
Correct. And so that's why my case is in the Supreme Court, because if you read my petition, it also shows that there's not been any jurisdiction at law or equity vested in any lower federal court. So now, if there weren't any, wasn't a common law court in the state of California, you could go to a federal court, although they say there is no federal common law. The federal courts rely upon the common laws of each of the state. But when you start to look into the federal rules of civil procedure and the the statutory federal question jurisdiction that's been granted to federal district courts, you see that there's no actual law and equity jurisdiction that's been granted to them. So the only other court, and Bill, you can chime in on this, otherwise, that seems to be a judicial constitutional court that has jurisdiction at law or equity is the United States Supreme Court. They are the only court created by the Constitution, and it says that the judicial power shall extend to all cases at law and equity. Well, where is it? Because they just sent, the clerk just exercised it, if you will, and sent my case back. So we have someone who's a clerk of court who has no authority to exercise that power, sending the case back and denying every single right that's claimed therein under the Constitution. So now Bill will say, well, time out. There's two constitutions in California. One of them's the 1849 Constitution, one's the 1879 Constitution. And because the 1849 Constitution wasn't repealed when the 1879 Constitution was purportedly ratified, we still have those courts that exist under that Constitution. But he knows as well as I do that there is no such thing anywhere in sight, even if we go down there and demand that that's what we want, because it goes back to something that, something you brought up or Bill brought up earlier that I was addressing, which is that it's very curious what's happening here, because either these people know what they're doing and they're deliberately doing it, or they have no clue what they're doing. And I mean, take it like this. In my case, they fined me $850,000. I have a Supreme Court case that came in 2020 that says what they did was a fine or a penalty, and they can't seem to figure out that that's what happened here. I mean, where do you even go with that? If the whole entire judiciary of California does not know what a fine is, where do you go with that?
Well, I guess, the thing that as I'm listening to both you and Bill speak, the thing that just keeps coming to me over and over again is stand in your power, stand in the standing. In other words, be common law, it's like if you keep putting out the vibe that what's the vibe? How do I want to describe the vibe? The vibe of being heard, being fairly treated, all those kinds of things. If that vibe keeps coming from me, then even the courts are going to somehow reflect that. That's, again, you all have all the knowledge about statutes and laws and stuff. I'm coming from a slightly different place in terms of energetically being what it is we want, for lack of a better way to say it.
Add on that real quick, Bill, and then you can talk about. Bill and I haven't talked in this regard, but Georgette and I have many times. And, a lot of what she's just talking about the energetics of all this, what's opening up is that the Constitution, the spirit of it, is actually written for all of us to stand in our power. And it embodies those principles of power, if you will. Georgette right now is going through a case involving foreclosure proceedings, and they basically, threw her out of court and didn't want to hear her. Well, guess what? Due process, or judicial process, as Bill calls it. Right there, you have the right to be heard. And if they don't want to hear you, it's the same thing in my case in the Supreme Court. There's all these principles that are embodied in the spirit of this law that, because all of this has been taken out of the curriculum and study of all of the public education institutions and probably even all the private institutions, no one seems to be getting this training on what it really means to stand in your power in this way, not just energetically, but even using the laws that have been created to reflect that embodiment of standing in your power. So I just felt that was really important to add, because it's like once you discover the power within yourself, you find that all these laws that not all of them, but a majority of them that are constitutionally based have, thousands of years of history behind them, and they're all about empowerment. So I'll leave it at that.
All right, well, a couple of notes here about all that business, and what you say is right, by the way. Just recently, I think the term last year in UC Berkeley, courtesy of Ruben Chemerinsky, they apparently relegated the one course they have on constitutional law to an elective. Well, what the hell? Why do you want to waste time and money on the course you're not going to use when you get out there in the State Bar Association? It makes sense to me. But they're simply not teaching it, even in law schools of this purported caliber, and probably not much else, either to Harvard and fail. I mean, you probably have some elite corporate attorneys that maybe get some of this in case they run into kooks like us and have to deal with it. But most people today don't have a clue. But that's not our problem, because they have sworn an oath to be bound, as I said earlier, by this Constitution. And we got to see when that's going to start to happen. A couple other notes here. We have a case from the California Supreme Court, thank goodness, in the days before Connie. Eleanor Valkenburg v. Brown, 43 Cal 43, 1872, after the ratification of the 14th Amendment, stating that no white person owed their citizenship to this amendment. True then, true now. It's a different body politic that was created there. And that's another exciting argument I'll be talking about on my uwinnincourt@gmail.com channel on YouTube, is that apparently that Constitution, and especially the amendments to it, have created a new body politic and a new state, but without the permission of Congress that would be required pursuant to Article 4, Section 3. It's not there. So to me, that brings up what I call the four magical words: the consent of the governed, and it ain't anywhere out there. We've not agreed to it. We've not made a voluntary, knowing, and intelligent waiver of any rights. And that's the reference standard of the U.S. Supreme Court. There's those pesky 9-0 parts again. Johnson v. Zerps, 304 U.S. 458. So they can't prove any of it. No waiver, no nothing, certainly no right to trial by jury according to the course of the common law. Oh, an interesting point there, by the way. If you can find it, you want to look up we call the Report on the Civil and Common Law, 1 Cal Reports 588. Now, I happened to notice recently, this is a few years ago now, but I was doing some work in another city, Modesto, I think, and was in their law library. And they had a recently reprinted set of California reports, conveniently printed in Beijing, China. Would have been much more appropriate in Pyongyang, North Korea. We have the same democracy. But these pages were conveniently omitted. They don't want people to read this report because it was quite, it was the bar of San Francisco. A lot of attorneys talking way before the state bar ever existed about the pros and cons, and talking about a lot of the issues that we're talking about right now. So if we were admitted as a common law state, since when has that changed? What's the factual foundation and legal basis? I can't find it. If you have, I'd love to see it. So let me see some more notes here. Oh goodness, I lost my place here a little bit. By the way, the other thing with Adam's situation in particular, and with all of us, because you get in these situations where you're supposed to have a license, and those of you who don't know, the Black Law Library Law Dictionary definition of license: permission granted by competent authority to do an act that without such permission would be illegal, a trespass, or a tort. Wait a minute, we created the whole government. When do we need their permission to do anything? Most particularly getting married for openers. And that's where they really get you, because they then monetize the birth certificates of your kids and now put them into interstate commerce. But when do we need their permission? They can't prove it. And when you go, for example, the vehicle code says no person shall drive a vehicle on the road unless he has a license. They can't even prove their persons, which are capitalized letters, by the way. And what that tells you is they're treating us as artificial corporate citizens. And wouldn't you know, that was a secret intent of the 14th Amendment that nobody who ratified it, assuming they had the capacity to do it in any event, was advised. Here again, consent of the governed. Where is it? Secret intent. And I can't think off the top of my head, but a daughter of one of the late 19th century Supreme Court justices wrote a tract on the 14th Amendment that was supposedly enacted to help the freedmen and end slavery and all this. And at the time, she said there had been less than 10 cases that got to the U.S. Supreme Court on that issue. One of them was the well-known case of Plessy v. Ferguson, story for another day. But there were over 500 cases with artificial corporate entities. And even the Supreme Court, by the way, was apparently in the dark about this deception until the case of Southern Pacific Railroad versus Santa Clara County in 1882. It took them 14 years. And this idiot New York attorney that was on the secret committee of 15 came in there. I'll think of his name for you in a minute. And advised the Supreme Court that corporations were citizens pursuant to that amendment. And they reversed the decision they were going to make in favor of Santa Clara County. And it came out in favor of the railroad, who couldn't be taxed. This is the kind of nonsense we're going through with this crap. And it has to stop. And I don't know what's hard about this, John Roberts, or Samuel Alito, or maybe you political hacks on there like Amy Coney Barrett was, prone to saying, and maybe you really are hacks if this is the way you're doing your job here. Prove me wrong. Start doing it. Do the issues. Decide Adam's case. Decide mine when it gets there. I mean, it's absolutely ridiculous what is going on here compared to what should be. Oh, the other thing, by the way, that we have other rights that they, especially in Adam's case, we have an unlimited power to contract, a right secured by Article 1, Section 10 of the U.S. Constitution, which, as far as I know, hasn't been repealed. This right would also be available, particularly with the 9th and or 10th Amendments, and those do apply. As I said, the Supreme Court said the Bill of Rights doesn't apply to the states, Maryland v. Baltimore, but that's Articles 1 to 8. 9 to 10 too. Those articles do apply. And we have those kind of powers, and we're presumed competent. And that's the big deal, people, because this is the only nation ever created in history where the innate worth and value of human life is recognized. Life, liberty, and the pursuit of happiness. Never before, never since. I think this is the only nation in which we have a shot at getting it back. And if we do that, we set the stage for the rest of the world to follow suit. That's even better. But that's where it's gone with the 14th Amendment. What happened was they made us all equal. They sure enough did, not by raising the freedmen to the level of state citizens, which could not have been done by that amendment in any event the way it was ratified, and that's with a capital R-A-T, because it would have had to been ratified by conventions of people in the states, not our agents in the legislatures, and certainly not the wartime legislatures that Congress created pursuant to the Reconstruction Act of 1867. And that, by the way, another reminder here, if I had learned that in high school, because the only thing we ever heard about Andrew Johnson was he was the first president that was impeached. They didn't tell you any details, nothing. He won the impeachment vote by 1 vote. But the reason he was impeached was apparently firing that Secretary of War, Edwin Stanton, which he should have been doing and had every right to do. But that was the Tenure of Office Act, which the Supreme Court decades later ruled unconstitutional. If I had read his veto of the Reconstruction Act in 1867 in 11th grade U.S. history, my life would have been different there and then. And the funny thing for me, when I'm sitting there in South Carolina, that would have been my 50th reunion from my high school, and I wanted to go for that meeting to see if my ex-football coach / U.S. history teacher showed up. He did more than one thing in those days. And I would have said, hey, Vince, you missed a few things. He would have got the joke. But it's not there. You don't learn any of this in school. The history is so warped. I'm not even going to begin to get into that. You can check out my videos on my channel, When in Court, on YouTube. I talk a lot about our history with chemical and biological warfare and the state of war at all, especially since the Spanish American War. There hasn't been one that should ever have existed, but that's a story for another day. But my goodness, it's just so bad when you understand what's really going on here. And we're trying to fix, and it won't take a lot of us to do it. The good news about that is, a few of us crooks like Adam and I and some others that I've been helping, we get out there and do things and bring this to the attention of the public and try to force these people to do their sworn duty here. If we can do that. And that's why I never got to a trial in South Carolina, because I got ruled competent, quote unquote, and they knew they couldn't have me in front of a jury unfiltered by one of their attorneys. It doesn't work that way. It was not designed to do it. It won't now. But you have to have enough knowledge, and you don't need near as much as what Adam and I had to do, because they're so colossally ignorant on the other side. You start talking about even a couple of three of these issues with some serious intent here, you're going to get their attention, and they're going to realize that it's not worthwhile to have you go in front of a jury either. Remembering that jury has the power to rule on the facts and the law. Georgia v. Brailsford. And that's the ultimate check and balance on these bastards, and they can't take a chance on having that happen in any way, shape, or form. That's what's still there, and that's what we have to get back. Oh, here I go rounding again. I know.
You're great. You're so great. Georgette, you have something to share?
Oh, go ahead. I'll pick up in a minute. I'm going to check my notes, but go ahead, okay. Adam. I'll review some things while you're doing that. So yeah, I got that one. Got that. Oh, just a quickie here, by the way, about needing a license, and their permission. Now, if you need a marriage license, and their permission to get married, you just wait. It hasn't happened yet, but it's going to. They may start in Texas, where they pass a law to declare that an unvaccinated parent is per se incompetent, and the Child Protective Services can summarily remove your child from your custody, and you never see him again. You wait, that one's coming. You just know it is. Another thing, by the way, on this subject, you just wait for the case in Minnesota up there with George Floyd, and you just wait. That conviction is going to be reversed sometime next year when the temperatures have cooled down. This, that, and the other going to reverse it, probably on the grounds of juror misconduct. And what may happen is, I can't think of the guy's name now, but he's going to get probably a reduced sentence, like what happened out here in California with Johannes Measurely, and who got murdered in a BART station here. And the idiot that did it ended up getting, I think, 18 months in jail and got released in under 14 for good behavior when he committed what was at least second-degree murder, if not first-degree murder. And yet, had the situation been reversed, you can be sure this victim would have been charged with first-degree murder. But guess what, people? There's those pesky 9-0 parts again. You have a case called John Baddock versus United States, 177 U.S. 529, in which they reversed the conviction for a man who was assaulted, and this was at the time in the territory of South Dakota, on an Indian reservation, by what were then peace officers. Now I call them law enforcement thugs. I don't know when that change occurred, but it wasn't when I was growing up. And they said, well, we have a right to self-defense, and the law enforcement officer didn't have a warrant, didn't have probable cause. And they further said on the facts of this case, you probably couldn't have convicted Baddock of manslaughter. That's what we need to get back to today. Hopefully, we're not going to have a lot of run-ins of this type, but we have the right to self-defense. If they're trying to enforce laws that we know and can prove don't apply to us, and we have no forum in which to make those points, particularly to a jury, what are we supposed to do? Just a little food for thought here.
Well, that's where we are. That's where we are. Georgette, did you want to share anything about your case and how some of the these issues are? I mean, essentially, what happened in your case, if you want to talk about it, is that you were denied the right to a hearing as well, even though you were there.
Well, nothing's coming to me about it. I'm doing another appeal with Adam's help. And putting one foot in front of the other and doing what I said earlier, just keep standing in, I do not consent to that fraud. I consent to this truth, that kind of thing. So
just to give a little bit of reference, what happened for her is she's going through, they're trying to foreclose on her for allegedly not paying some money that's due to the mortgage company. So they conducted a hearing, gave her notice of the hearing, and then in that hearing, the judge issued an order that the foreclosure sale could move forward, but then they never gave her notice of that judgment order. So she called the court about 3 weeks later and said, what's going on with the case? Well, they told her at that time that an order had been issued. So immediately within the 10-day statutory period, she filed notice of an appeal. That was to be, I think it was October 5th. So she shows up at this hearing on October 5th, and the judge says, well, you didn't file a timely appeal. You were without the 10 days that you had from statute from the time the judge issued the order to the time you had to file notice. And she said, well, wait a minute, I was never given notice of the order. So,
and he said, I know, and I have to follow what I think is the law.
Oh,
So, of course, our whole argument is, based, principally on due process or judicial process. You have to give people notice. That's essential to everything. And they did not admit one single item of evidence in her so-called hearing that showed that she was ever given notice of the foreclosure sale. And of course, I know Bill's over there he's writing a whole new
well,
habeas corpus over there for her, define dollar and urine admiralty and foreclosure and
I did
going with the simple stuff here, but the whole basis of this is that because the judge had no authority to deny her a hearing, I mean, that's treason. He just literally exercised the judicial power of North Carolina to deny her a constitutional right to a hearing where that whole proceeding that took place was also without jurisdiction. So now she's filing an appeal to that, only to have, probably if they even find in her favor, to have the case sent back to the court so that she can have a hearing and present evidence. Well, it's not even her burden, that the foreclosure sale had no jurisdiction. So anyways.
There was one other. Did you finish?
Yeah, I just wanted to say it's not just Bill and I that are, doing this. I mean, Georgette would readily admit, she says, I don't know any of this stuff that you guys know. And yet she's being empowered to stand in her power and, learn these things. And go to court and shake like a leaf and,
speak my piece.
Well, I, as you well know, I've been there, done that too, shaking and stuttering and blah, 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 just not knowing what to say or what to do. And, obviously that's changed now, but, that's it. You're engaging in it and you're not running away from it. And, you're showing up, even though there might be trembling in the body or you might be experiencing fear and you don't know what to say, but you're showing up. And then as you do that, the same in my case, and Bill will attest the same thing. The truth always reveals itself. It always does.
And, I found one other little thing in the judge's order that was not, that I didn't get notice of. And it said this, I just want to share this with you all. It says that, let me find it here. She's giving an order for a new foreclosure sale for the real property, which is the subject of the above captioned special proceeding being conducted subsequent to substitute trustees meeting all notice requirements.
Yeah, well, they didn't meet the notice requirements.
Yeah, so they can't go on with the sale because they didn't meet the notice requirements. That's what this is saying.
Yes, exactly.
Okay. I just
Yeah.
wanted to make sure I was understanding.
Well,
it right.
actually,
Okay.
maybe that I might be incorrect about that. What it may be saying is that if the substitute trustee complies with all the notice requirements required to give you notice of the proceedings, then those proceedings can move forward. But again,
That's the way I understand it.
yes, but that hasn't happened yet. So it's not something that they haven't complied with. If that makes sense. This is what they're talking about is a future proceeding. So in the future, as long as the trustee complies with those notice requirements, the foreclosure sale can proceed. But what he doesn't know yet is that that special proceeding that they had was void and that you're challenging the jurisdiction of that proceeding. So it's not going anywhere. So he had no lawful authority to make that order because he could only make that order if he gave you a hearing and heard your challenge to jurisdiction, which he denied.
No, this was in Finkelstein's order.
Oh, I thought
back
you said
August 10th.
Okay.
No, this is August 10th. And I didn't read the whole thing. It says subsequent to substitute trustees meeting all notice requirements as stated in the terms and conditions of the documents and by relevant law.
Okay, so yes, if you roll back the clock, they never gave you notice of that order, so they never had authority to present the foreclosure proceeding. And again, this is aside from all the other way big constitutional issues that we talk about. We're just keeping it on this, you know, their playing field right now, so to speak.
Yeah.
And
I just wanted to share that with you.
Yeah. No, thank you. That's great.
And I'm so proud of myself because I noticed that.
And you should be. But I mean, that's the beauty of what's happening is Bill, she's calling me, sometimes 2 and 3 times a day or emailing me and telling me about these things that she's found. And it's just so beautiful because she's engaging herself in reading this stuff and, going through the motions of like, well, what does this mean? And, she'll ask. And then, now she's starting to put all the pieces together to see, even in this scale, even just at the so-called statutory level, that they're just a disaster. They don't follow their own rules. And I don't know if they know what they're doing or they don't, but it's an atrocity.
And I must add that Adam helps me keep focused. There are times that I call him or send him an email saying, what about this? Nope, forget it. So there's that too. And I thank you for that.
Oh, you're so welcome, sweetheart. You're so welcome. Yes.
Yeah, if I might say so, that's part of the process. And I didn't get it overnight either. I was something of a slow learner. But when you start studying and you realize the true situation and perspective, that's when you get the real value of life that we're supposed to have. And you go out there and you go into their courtrooms like I do, and I say it with attitude and with authority in their faces. Now, your situation, Georgette, I'll get some things, and I haven't noticed a lot of this, but the problem they're going to have with the mortgage lender, quote unquote, is number one, they haven't made effective service of process. There's that pesky U.S. Supreme Court again, Penoria v. Neff, 95 U.S. 714. And to do that, what they would have to do, since they treat us all as corporate citizens now, 14th Amendment, right? To serve a corporation, what do you have to do? In your case, Georgette, they have to serve your designated agent for service of process in Raleigh. But you probably don't have one, do you?
Have
and
one.
You don't need one.
One what?
Designated agent for service of process. If you're a corporation, that's how they get corporations into their courts. That's how they're treating you. But they haven't done it and they can't do it. And it gets even better because with corporations, the rule for citizenship comes out of a case called Bank of Augusta v. Earl in 1839, I believe. And the corporate citizenship relies on the state citizenship of those who incorporated it. If we can prove there are no states, and I have an 83-page brief unopposed on that subject, they're not there. They don't exist. We do, they don't. See you later. That's how that works. You get people out of here, and here again, we get back to see, I'm just checking my notes here, be sure I get everything in here.
And while you're doing that, I'll say, when I was in court 2 weeks ago, I asked the judge about the difference between the name on the documents in front of him and me, the living woman, but he wouldn't answer. I asked him 2 or 3 times and he wouldn't answer.
Well, I can't do that on the record, because if your name is in all capital letters, they're treating you as a corporation, like I just suggested. And that's treason to the Constitution. Oh, by the way, they simply can't. And, I'll get Adam to get you. I know he has some quotes from a case called Windsor v. McVeigh. No, not Tim McVeigh, who I think maybe got screwed over in Oklahoma City, but this one is in 1865. And you read what the Supreme Court has to say about notice and opportunity to be heard. It's a stunner. But it just, wow. They should make decisions like that these days, John Roberts. Why don't you review that case and get on it? My goodness.
What
And
did you
getting back
call
to
it?
Cohen's v. Virginia, here's another quote from Cohen's that talks about where the court says that, any state that uses paper money, to pay off debts, all they do is they discharge the obligation. The debt is still due. There's no way for you to pay the debt with paper money, which is all they learn by hitting a few strokes on their keyboard and transferring money to your account, quote unquote money. That's it. They don't have anything. And at common law, that would be an affirmative defense, and they wouldn't even have filed a claim, let alone gotten it to a jury, if North Carolina was the state admitted into this union, which at one time it was. These are the kinds of jurisdictional traps that they're going to be running into. And we're just loaded with them. I mean, it just doesn't stop here. And let's see the other one I have here. Oh, yeah, I mentioned the McVeigh case. By the way, that's Windsor v. McVeigh, 93 U.S. 274. Those of you get on my Win in Court site at YouTube, that's one of the bonus documents you get with a lot of quotes from that case. It'll really wake you up as to what should be happening and should still be happening now with our right to be heard in a common law forum. If we get that back, we put them out of business. That's the magnitude of the issues. And ultimately, Georgette, that may be what wins your case, because with these issues, if you're a mortgage lender, I would not want to risk having any of these issues come out on the public record for openers and any one of them getting ruled on by a court, because if that happens and they're unopposed issues, they have to rule in our favor, don't they? And that undoes every mortgage from Portland, Maine to Portland, Oregon. It's all the same issue. It isn't just your case here. That's the power we have. And just, but if we just knew that and learned it in school and went out there and could manage our affairs. And that's the other thing. This system thinks that we're innately incompetent to do anything. As Adam knows, you walk into their court, particularly in a quote unquote criminal proceeding, but really in all of them, they presume incompetence, like they did with me in South Carolina. And when that happened, if I could have thrown up my hands, I would have. When the judge said that, and I said, "Oh, here we go, Barfetta," which I call Prevetta v. California, Judge 422 U.S. 806. The problem with that is the Supreme Court said in Barron v. Baltimore, 7 Peters 243, 1828, the Bill of Rights doesn't apply to the states. Stunned the courtroom into silence. You've never seen anything like that. But that's the problem. If they're going to presume, think about this, if they're going to presume we're incompetent, how does the prosecutor prove we have the competence to form the criminal intent to commit the crime?
Cool.
Even better yet, think about this one. If we're incompetent, how do we magically regain quote unquote competence on election day?
Wow.
I mean, it's ludicrous when you think about it. And that's what studying does. You start to put pieces like this together and you say, my goodness, you go from A, B, C, it all comes together. And it didn't for me either. It took me, I was a slow learner. It took me 10,000 hours in those musty old stacks of law books back in the day when I could get into UC Berkeley across the bay, the 5th largest law library in the country, and later Hastings in San Francisco, neither of which I can do now. But yeah, it could come together and you say, what in the world has happened here? And we're trying to fix it. And whether I get across the Red Sea, I don't know. I'm now 73, and with family history, I got a good 8 or 10 years, maybe a bit longer with that, since I very rarely get big pharma stuff. But the funny thing for me, last year I went through a session with enlarged prostate, and I went in there and they asked for a medical history, and I laughed and I said, I don't have one. 71 years old. They asked what was the last medication you took, and I said, gee, that goes back to 1992 when I took some medication for I can't think right now, but I took medication. I had a bad case of pneumonia, which is going to be the COD for me later on. And I took some medication then, but I've never been big on taking any of the big pharma medication. I was brought up in a family that we had people in the earlier generations. In fact, my great grandmother was the informal town doctor of the town she was in, because the doctor they had also doubled as the town drunk. So she ended up doing a lot of medication. Actually, charged her with practicing medicine without a license these days. But she was very good at what she did. And my mom learned from her, and my grandmother learned from her. And they, in turn, taught me a lot of things coming down the road. So, and I was never sick. And I'm thankful every day for my great health. That's every day I am, because I know how important that is. So it is what it is with that. But yeah, you start thinking about all these things and you're saying, how are they doing this? But if we make timely objections and get it on the record, as I said, that's the power we have, because one decision like this, especially from the U.S. Supreme Court, it changes everything. The whole equation happens. And now we get back and quickly. And that's what I want to do. And that's why we beat them in front of a jury, because there's going to be a good chunk of change that we're going to get, you're going to get, all of us will. But we get in front of a jury, they're going to see we're there to make differences in how they do business. And that will affect the jurors and their families. We're going to have a lot of credibility. What do we have on the other side? A dozen attorneys sitting over there in $2,000 designer suits. Thank you very much. That's not much in the way of credibility, is it? That's all they're there for, is the money. And that's why we're never going to see. Well, I'm never going to see a jury. I haven't, and I won't. I'd be shocked if I ever. I'd love it, but I'd be shocked if it happens, because they simply can't risk it. That's the system is still built that way. So that's sad. I've really gone on and on here a bit, but hopefully you make some good points to the listeners out there. And like I say, you visit Adam's website, thespiritoflaw.com, and mine at When in Court on YouTube, and you can learn a lot about how this stuff works and what you can do about it, and teach your children and your posterity to do about it. And I still am naive enough to think that there is. I mean, I can't believe the founders went through all this, to create the government they created and to have it come out this way. Although there are those that say we may have been sold out by the Treaty of Paris in 1783, and there is an argument to be made there beyond the scope of this video. There is something to be said for that. But we've lived for 230 years in good faith belief that we have a constitution, and I'm going to continue to do so unless or until the contrary clearly appears. And quickly as I answer, by the way, I'm Donald Trump, with the quote unquote election last year. And of course, there's no presidential election, but you'd be much better making that argument that, there was a lot of fraud in that election. And that's because the voter registration forms prohibit at least any lawful de jure, jus sanguinis, free white state citizens from registering to vote. Where's the consent of the governed here? That's the issue they should be deciding in the U.S. Supreme Court. That's a winner chicken dinner. Oh, goodness. That said, back to you, Adam.
Well, I'm feeling great. We've been at it for an hour and a half, and really shared a lot of wonderful, beautiful things. And it's a whole lot of stuff for someone maybe just coming to this to digest. But Bill does have an amazing YouTube channel. It's called When in Court. And, hopefully we'll all get together and do some videos to keep updates with what we're doing, especially, too, with Georgette's case. if you have any questions, you can go to thespiritoflaw.com. There's a contact form there, or Bill's email is youwinincourt@gmail.com. And thank you.
Thank you all.
Oh,
It's been-
thank you too. Enjoyed doing this. Would love to do it again sometime, and I'm sure we will be. Whether I'll be in there doing it from a jail cell, I don't know, but we'll just have to see how that turns out. Because the problem is, I've been out here in California 40 years. I've not been able to get into jail here. It took South Carolina to do that.
Do you want to leave with a kiss for John Roberts, Bill?
Oh, I don't know about that. It'd just be nice if people started to do your job, for the first time in 160 years. I know you got the message with the McArdle case, when they couldn't announce their decision that ruled the Reconstruction Act unconstitutional, which affected the same thing to the 14th Amendment, and that's all they have. So we'll see, Adam, but it's been such a great fun doing this, and I'm sure we'll be doing it again for you listeners out there. Look out, we're not going anywhere here.
Wonderful.
Wonderful. Thank you.
Okay, well, thank both of you.
Thank you
Look forward to
both.
seeing you again.